Hear ye, hear ye, hear ye. The Court of Appeal for the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Thank you. We have two cases on our docket today. Our first case is working out some technical issues, and we're going to proceed with our second case now. It is cause number 14-20-00004-CV, North Cypress Medical Center and Dr. O'Dilley versus Randy White. If counsel would make their appearances for the record.
Your Honor, Roger Berger for Dr. O'Dilley.
Your Honor, Larry Adams from Memorial Hermann Hospital, North Cypress Hospital.
Jacqueline Stump for appellee Randy White.
All right. And the appellants are going to split their opening time. And we are ready. Mr. Berger, when you are, what's going to happen is the other council pictures will go off screen. All right, we are ready for you.
May it please the court, counsel. I represent Dr. Ozochukwu O'Dilley, an ER doctor who saw appellee Randy White in the emergency room. Mr. White was injured on the job when a large toolbox fell on his hand. He was brought to the emergency room from his workplace, and Dr. O'Dilley worked him up. He did x-rays. He diagnosed a thumb fracture, he cleaned out the wound, he irrigated it, he sutured the cut, and then he called the on-call orthopedic surgeon, who was Dr. Tanous, who's not a defendant, to present the case to Dr. Tanous and asked what Dr. Tanous, the orthopedic surgeon, would like him to do. Dr. Tanous told him to have the patient come to the office on Monday. The injury was on a Saturday. The patient, instead of going to Dr. Tanous, went to a different orthopedic surgeon and was worked up. That orthopedic surgeon, Dr. Siagla, waited for several days before doing surgery, ended up doing several procedures, and according to the plaintiff's petition and expert report, suffered a 9% impairment from the injury. Plaintiff served a expert report, which was a one-page unsigned letter from a Dr. Ramesh Srinivasan. 2 weeks after we filed our answer, we promptly filed objections. And then after another 100+ days, when no further reports were filed, we filed a motion to dismiss. In the motion, we had several grounds. One was the qualifications of the orthopedic surgeon to opine against an ER physician, and the other was the complete lack of substance in the one-page unsigned letter. The letter did not address a standard of care for Dr. O'Dilley, did not say Dr. O'Dilley breached a standard of care, and did not address proximate cause at all. The only time that Dr. O'Dilley was even mentioned in the report was a 5-word sentence saying he was evaluated by Dr. O'Dilley. At the hearing on September 23, 2019, Judge Dollinger got almost everything right. He ruled that the report was inadequate because it did not address standard of care, did not address breach, and did not address causation. The only thing wrong, we submit, is that he did not dismiss the case at that point. The rule, the statute, and the case law require that an expert report from a qualified expert be submitted that addresses the 3 elements, standard of care, breach, and causation, and do so in a way that informs the defendant of exactly what it is he or she did wrong, and informs the court how the plaintiff is going to make the case. This report did not do that. Under Scoresby, the Supreme Court articulated the minimum standards for an expert report in order to get an extension to cure. In this case, the report did not meet those meet those requirements. Precedent from this court also requires dismissal. We cited in the breach the Villandia versus Contreras case, in which the court noted that the report did not meet the minimum standards and no cure was possible. Dismissal was required. Instead of dismissing, Judge Dollinger spent a considerable amount of time telling the plaintiff exactly what they needed to do to cure. He said that you have to articulate exactly what the standard of care required of Dr. O'Dilley and how you came up with those standards. You have to articulate exactly how Dr. O'Dilley breached the standard of care and show the details. Finally, he said that you have to explain, but for the breach, the patient would have had a better outcome, and this is how the outcome would have been avoided. The conclusion that Judge Dollinger made was, counsel, you have to hit the nail on the head. You have to write it right, because there'll be consequences if you're sloppy. Instead, Appellee's counsel filed an amended report that was only slightly more detailed, that still did not connect any alleged breaches of the standard of care by Dr. O'Dilley to the injuries and damages. It did not say anything that Dr. O'Dilley did proximately caused injuries or damages.
Mr. Berger, in regard to that second report, the second report notes that there was a delay in treatment and in referring Mr. White to a hand specialist. So in addition to that, that report notes that in order to avoid the risk of infection and subsequent non-union, hardware failure, etc., that there should have been either a clean wound or immediate referral within 24 hours to a hand fellowship trained surgeon.
Yes, Your Honor.
What is your argument that does not comply with the requirements of Section 74 of the TMLA?
We actually did not challenge the second report as to standard of care or breach, only the qualifications of Dr. Srinivasan to give those opinions and the proximate cause.
Well, in that regard, then, Mr. Berger, if you're not challenging the first two and you are just challenging the qualifications, do you agree that the requisite qualifications focus not on the defendant's area of expertise, but on the condition involved in the claim, which in this case would be a hand injury?
Yes and no, Your Honor. In this particular case, Dr. Srinivasan is opining about what an ER physician was required to do by the standard of care. He has to show that he has some knowledge of what an ER physician does as opposed to an orthopedic surgeon. No doubt he's qualified to opine about the orthopedic surgeon, but that person was not a defendant. Dr. Srinivasan just didn't put that forth in his amended report.
But isn't that focusing on the doctor's area of expertise rather than on the condition involved in the plaintiff's claim?
We would submit, Your Honor, that in order to satisfy the qualifications issue, he's got to show that he knows what the emergency room physician has to do in terms of who to call and when to call, not surgical issues or what to do when the surgeon gets him in terms of timing.
All right, your time is up. We'll let Mr. Adams come and then we'll hear you on rebuttal.
Thank you.
Thank you.
Afternoon, Your Honors.
Afternoon.
I represent the hospital in this case, and I don't think I need to go into the details that Mr. Berger went into. But basically, our position is the report was totally deficient and offered no good faith effort to comply with Chapter 74. And the main reason we say that is nowhere in the report does it set out a standard of care, breach, or causation as to the hospital. The only thing said about the hospital in the amended report was that the hospital did not have on call a specialized, trained hand surgeon to consult with the doctor. Nowhere in the report does it explain that the hospital had any duty to have such a person available, nor does it say that the hospital did not have one available. And in addition, it made no comment as to what could have been done by this specially trained hand surgeon had he been called in. And of course, as this court knows, the hospital doesn't call in consultants, the treating doctor does. So basically, the way I read the report, he has no complaints against us. He does not set it up by any standard of set out by Chapter 74. And he gives no reasons why we should be in the case. And we think that the direct liability claim against the hospital should be dismissed.
Is
Now,
there a vicarious liability claim against you also?
They do have a vicarious liability claim. And in the event the report is good as to the doctor, then they should be able to go forward with it. And I'll let Mr. Berger speak to that.
All right, thank you.
Thank you.
All right. If you are finished, we'll let Ms. Stump go next for Mr. White.
Good afternoon to the court. Can everyone hear me?
Yes?
Okay, thank you. I'll proceed. Thank you. As this esteemed court is aware, we're here today under the abuse of discretion standard, and we submit to the court that as fully briefed, as this court has been fully briefed, that the district court did not abuse its discretion. There was no arbitrary ruling. There was no unreasonable ruling. The district court's ruling was squarely within Texas law, specifically Chapter 74 of the Texas Civil Practice and Remedies Code, as well as Texas jurisprudence from this court, as well as the Texas Supreme Court. As a threshold matter, this court is aware that there was a report submitted originally, and by order of the district court, we amended that report and was submitted timely an amended report, and there was a hearing had on December 23rd of 2019 on the amended report. I would like to mention regarding the qualifications issue, first of all, is that was the doctor, our plaintiff's expert, Dr. Srinivasan, was ruled to be a qualified expert in the first hearing on September 23rd, 2019. And the judge indicated he would take it up again as the report was amended as to other matters, such as the standard of care. So I'd like to point that out. And then on the December 16th, 2019 hearing on the second round of motions to dismiss, the amended report, our plaintiff's expert, Dr. Srinivasan, was also held to be qualified. So I'd like to address that issue first, but I'd also like to address the issues as to the alleged deficiencies in the amended report that was filed and heard on December 23rd, 16th, 2019. I'm sorry for getting confused as to the dates. So in regards to the qualification, we submit that plaintiff's expert, Dr. Srinivasan, is actually extremely qualified under Texas law to give an opinion and testimony in this matter. His qualifications have been set forth in his CV, which I believe is Exhibit C to this hearing, as well as it's contained in the court's record. He is an orthopedic surgeon. He also has a specialty in upper extremities, which is the hand. He also takes call in the emergency room setting for the upper extremity. So we submit that he is very, very qualified to give opinions in this area. He's worked on many, many surgeries and many, many problems with the upper extremity and the hand. He actually trains fellows in hand work. So we submit that he's extremely qualified. In regards to what Chapter 74 requires, they require that he be a physician, which he is, that he's currently practicing, which again, he is currently practicing in the area of upper extremity, and that he be well-versed in the treatments that are required of this type of injury, which he is. So we submit that he has met those requirements as far as the qualifications. And also just to point out, as we've briefed in some of the Texas Supreme Court law regarding there's no requirement to specialize in the ER setting. It's more of to the area of injury, as this court has already addressed today. So I'd just like to submit that we believe that he is qualified. And I'll move on now to regards to the actual report. Sorry, one second. the expert report in general is required to be a fair summary of the expert's opinions and is less than, it's not a trial on the merits. It does not require the plaintiff to fully marshal the evidence. It must be a good faith, objective, fair summary. And we submit that we have done so. Taking the amended report, which I believe is Exhibit B to the exhibits to this hearing and also contained in the record, the amended report ordered by the district court clearly sets out the standard of care for Dr. O'Dilley individually, the hospital directly, how the standard of care was breached, and how the breach and the acts and the omissions of the standard of care was the proximate cause of the damages suffered by plaintiff in this case, or I'm sorry, by appellee Randy White in this case. And in this case, to give the court a little more information, he does have the impairment rating. He was a mechanic and is unable to use his right hand because of the injuries to his hand. So those are—
What do we do with the fact that the report has two different scenarios? One is that he didn't properly clean the wound, and that maybe is what the problem was. And one was that he didn't refer him to a hand specialist within 24 hours. What do we do with those alternative causations?
I think based on what the records show, which is all we have at this point because we haven't been able to conduct any discovery, those are both breaches of the standard of care in our expert's opinion. He is supposed to grossly clean the wound, and he is also supposed to refer within 24 hours to a fellowship trained surgeon, and neither of those were done. So we submit that those are both breaches of the standard of care.
Does it state in the report that the wound was not grossly cleaned?
I believe it does, Your Honor, but let me try to see if I can— I don't want to misstate anything. I'll pull it up quickly.
I mean, he seems to suggest that at the end of the report, but I didn't see in the report where he said, based on the medical records he reviewed, that the injury was not as clean as it should have been.
And Your Honor, if I could point the court's attention to the amended report, which is Exhibit B to this proceeding, page 2, the last full paragraph. It's about the third sentence. Alternatively, if the wound is grossly clean and irrigated with 1 liter of normal saline, it can be referred in delayed fashion to a hand fellowship trained surgeon after consultation. The medical reasons that may mean records I have reviewed do not indicate a medical reason that Mr. White's case could not have been referred with a hand fellowship trained surgeon. And then going further down to the conclusion, in all medical probability, Mr. White would not have ended up with an infection and subsequent impairment if Dr. O'Dilley had obtained a grossly clean wound or provided immediate referral for surgery to a hand fellowship trained surgeon.
Well, there's nothing in here that indicates on 313 that the hand was infected, right?
That's correct. I believe that my understanding is that they believe the infection likely resulted from the wound not being properly cleaned, which is a breach of the standard of care. In this field, in this specialty, it's something, the term is grossly clean. So it's supposed to be irrigated with the 1 liter of saline solution in order for the wound to be grossly clean. And that was the reason when Mr. White visited the second surgeon, that they were unable to perform the surgery the day that he went in because of the infection, which our expert believes is because it was not properly irrigated, if that answers the court's questions.
Can you address the issue of the expert report in terms of liability, direct liability against North Cyprus Medical Center?
Yes, Your Honor. In regards to the direct liability of North Cyprus, I would like to refer the court to the last paragraph on page 1 of the amended report, which is Exhibit B, which goes on to page 2. So it's one paragraph. The standard of care in an ER setting for an injury is how this paragraph begins. There was a breach in the standard of care by Dr. O'Dilley for not immediately consulting a hand fellowship trained surgeon, or North Cyprus for not having hand fellowship trained surgeons available to Dr. O'Dilley for consultation. And I realize, that has an or in there. I think at this stage, this is a fair summary of our expert's opinion based on what he knows right now, we don't have all, we haven't had any discovery, we haven't had depositions. So it is a fair summary and an objective good faith effort on his part to determine what actually happened without us being able to actually ask someone what happened. We don't know. But we do know that that was not available to him, presumably because the doctor did not refer him to a specialized surgeon, as is the standard of care in that very specific specialty area of upper extremities. But again, is also very common in the ER setting it's my understanding that they have a very common bank of people that they would call, because in the ER setting, obviously you're seeing a lot of different injuries. And that's the direct allegation of liability against North Cyprus.
But that's what you're saying, but your expert didn't say that. Your expert didn't say that the standard of care requires a medical center the size of North Cyprus to have all of these specialists on call. The report doesn't say that anywhere.
And I'm sorry, Your Honor, that my computer cut out for just 1 second, but I didn't hear the first part of your question. Your Honor, we feel that it is, if it's not stated to the court's liking in this expert report, we do feel that the district court ruled that it was sufficient and that was not an abuse of discretion. It was reasonable and grounded in Texas law and jurisprudence is how we feel the district court ruled as to that issue.
And can you explain the doctor's qualification, your expert's qualification to make that assessment?
Absolutely.
In regard to the hospital.
With respect to the hospital.
Right.
With respect to the hospital. Well, again,
other than working in a hospital.
Other than working in a hospital, yes, I understand. Well, my understanding of the law, and again, so not being in the medical field, but my understanding of the law is that it's not it's not necessarily the requirement to be specialized in the area of hospital. I don't know if it's a hospital administration or whatever the term might be, but it is, what is the standard of care for them to adhere to as far as providing that to the employees in their hospital. And that is the standard of care that Dr. Srinivasan has opined as to in his qualifications as not just not a physician, but as a specialty trained surgeon who regularly teaches fellows as to this hand specialty. And is very familiar with the system of calling and getting a specialist. I mean, I didn't know about that before I worked on this case, but you learn something from every expert. And that's my understanding of the standard of care for the hospital as well. I'm sorry, I don't see the timer. Let me see.
You have 3.5 minutes left.
Okay, thank you. I see it now. I'm sorry.
Mm-hmm.
I'd like to probably just address a few more things since I have a little more time. One thing I would like to say is that something that I believe my colleague, Mr. Berger, said was that there was a delay in the subsequent surgery. So after he went to Mr. White, my client went to see someone else, they waited to do surgery. Well, I wanted to point out to the court, the reason they waited to do surgery was because the wound wasn't properly cleaned when he went into the emergency room at North Cyprus. And because they presumably did not use the 1 liter of saline to what's called grossly clean the wound, it was infected. And there was a lot of things wrong with it. And there was pus and things. And so they had to abort the procedure and he had to come back. So it's been a complicated road for my client. I just wanted to explain a little bit more about that. And, just to ask the court to consider that, the district court followed the standard set forth in the case law and set forth in Chapter 74 as to the fact that this was an expert report that was timely served, it was properly amended within the 30 days ordered by the court. It set out the standard of care, both for Dr. Dilley, for the hospital, the breach and the acts of omissions that constitute the breach, and also the proximate cause of the injury to my client, which is the loss of the use of his hand. So we would just like to ask the court to affirm the district court's ruling, and we thank you very much for your time today and welcome any additional questions that you have.
No, thank you very much.
Thank you.
Now we'll have rebuttal from Mr. Berger first.
Thank you, Your Honor. A few points. First of all, to answer you, Justice Jewell, about whether the report says that the wound was not grossly cleaned, it does not. It says on page 1 of the amended report and the only page of the original report that Dr. O'Dilley irrigated the wound. That's how you clean it. It does not ever say that Dr. O'Dilley did not clean the wound appropriately. That's not part of the alleged breach of the standard of care. Justice Christopher, you asked about whether there was anything that indicated that the wound was infected. There's nothing in the report or reports that indicate that the wound was infected on the Saturday during the emergency room treatment. There's nothing in the reports that says that the reason why Dr. Siagli could not do the full surgery he tried for 3 days after his initial visit on Thursday was related to Dr. O'Dilley not properly cleaning the wound. There's simply nothing in the report about either of those things. There's nothing that says the delay was because of something that Dr. O'Dilley did or failed to do. In terms of causation, as we've noted in our briefs, there is no how and why description. How it was that Mr. White's injuries somehow were caused and why they could have been avoided. Those are requirements by our Supreme Court. They are not in any way addressed by either of those reports. In terms of the qualifications, our legislature has decided that emergency room physicians are treated differently. We have a special willful and wanton standard. We have special jury instructions, and the cases are just treated differently. I've cited in the brief several emergency room cases, Hagedorn and Cox versus Vanguard are two of them, in which the courts analyzed the plaintiff's proffered expert and concluded that there was nothing in the report or CV to show that those experts had ever treated patients in an emergency room setting, had ever practiced in an emergency room, or were otherwise qualified to opine on the standards of care for emergency room physicians. That's why
But the plaintiff's expert in this case has gone to the emergency room to treat hand.
He's gone to the emergency room when he's called by the emergency room physician to do the treatment. He doesn't sit there for 8, 10, 12, however many hour shifts and determine what to do with the patient, how to disposition themselves and the patients in terms of discharge, admission, consultation, or things like that. He's the one that's called, and that's why he would be capable of opining against the orthopedic surgeons in this case, but they're not parties. I hope that answers your question.
Well, we certainly have a lot of cases out of 14th Court that says the qualification goes to the type of injury, not the type of doctor.
I understand that, Your Honor, and I accept that. The other key issue is the how and why causation. We contend there's an analytical gap in Dr. Srinivasan's opinions. I think this court issued an opinion a couple years back in Humboldt Surgical Hospital versus Davis on that very point. That went up to the Supreme Court and petition was denied. This court has most recently on December 29th issued an opinion in Aquatic Care Programs versus Cooper, reversing and rendering judgment for the defendant. Now that case was a little different because there was—
Mr. Berger, I hate to interrupt you, but
Sure.
How do you address the sentence in the report that says that Mr. White would not have ended up with an infection and subsequent impairment if Dr. Udila had obtained a grossly clean wound or provided immediate referral for surgery to a hand fellowship trained surgeon?
We have asserted in our briefing, and I do contend that that is a conclusory statement that needed more details about how and why the result was related to Dr. O'Dilley's alleged negligence. There's nothing there other than the bare conclusion. There's no support for it other than his ipsy-dixit statement.
All right, thank you very much.
Thank you, Your Honor.
We'll hear from Mr. Adams for one last minute, I believe.
Thank you, Your Honor. I would just like to reiterate what the court talked to plaintiff's counsel earlier about where in the report there were any qualifications whatsoever that allow this expert to give an opinion about what a hospital should do or not do. And as the court pointed out, there was nothing in the report along those lines. So he's definitely not qualified to testify about what a hospital should or shouldn't do. He may have the ability to do so, but he didn't do it in the report. And that's all we can go by. Thank you.
Thank you very much. All right. Thanks to all counsel for the argument in the case, and you are excused from the courtroom, the virtual courtroom, and we're going to see if our second case is ready.
Thank you, Your
so
Honor.
much, court.
Thank you.
Thank you.
All right. Ms. Clevenger, Mr. McQuaid, were you able to work out the representation issue?
Your Honor, yes, if I may. I was just going to say, we didn't talk to Mr. Brooks. Ms. Clevenger assures me he doesn't want me. He wants her. I'm taking her word for it and graciously stand down.
All right.
Your Honor, and before I proceed with this statement, I want to apologize to the court and to counsel for any inconvenience, but I would really prefer that the court nor Mr. McQuaid rely on my word alone. I would prefer that Mr. McQuaid hear it from my client directly. I have attempted to call him several times and also reach him by text and have not been able to contact him. As such, I'm respectfully requesting that the court reset this until my client is able to confirm this with Mr. McQuaid.
Well, that seems reasonable. Mr. Walker and Mr. Laporte, I'm sorry, but as I indicated to you before, I felt the best course was to reset if we couldn't, pin this down correctly. And so we will go ahead and reset this matter. As soon as you know and have everything ironed out with the client, let us know and we will promptly reset you.
Thank you.
Your Honor.
All right. Thank you.
Your Honor, we appreciate your time. Thank you.
All right. The court is adjourned. Thank you.